The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to Moore Law. Today we are giving you the chance to ask a question about any area of the law. From divorce to criminal defense, workers' comp to wrongful death, no legal question is off limits. Do you need an attorney? If so, what type of attorney would be right for you? Is there a time limit to get your legal problem solved? If you have a question about the law, this is your chance to ask us anything. Give us a call at 513-421-4691. And we want to take a look before we go to the phones about some of the things that will be coming up over the next couple of weeks. On April 30th, we have All About Injuries. May 7th, Divorce and Child Custody. And on May 14th, we'll be talking about what to do if your kids get in trouble. Joining me today and every Monday, of course, Don Moore. Don, you are really excited about people asking us anything.
This is going to be a lot of fun. Frankly, this is my life and has been for over 30 years. And we've got a special guest today, Margo Grubbs. She may not want to admit it, but she and I are about the same vintage, and she too has been practicing for over 30 years. Welcome, Margo.
Thank you for having me. I appreciate it.
Well, thank you for joining us. Can you tell us just a little bit about how long you've been practicing?
32 years this year. Don and I actually were classmates at Chase Law School back in the late 70s.
Wow. Well, we are glad to have you with us. And Don, I think you wanted to start by talking a little bit about the statute of limitations. It's different for different states. There are different rules within the same state.
It is. Thank you, Deb. We have limitations of time in which you can file something, and I wanted just to start to show off with that just for a second. I know we've got callers waiting, and we're going to get to them quickly. The statute of limitations is the drop dead deadline for you to file a claim. You miss it, you don't have a case anymore. It's just as simple as that. And there's the statute of limitations for injury cases, and there's the different statute of limitations for property cases. And you've seen some of the graphics up on the screen there. The personal injury cases are the ones that I deal with most frequently. And Margo and I talked a little bit about the Kentucky statute of limitations for injury cases and how that varies. Actually, they all vary a little bit. The takeaway is it's a drop dead deadline. Now, Margo, tell us a little bit about the Kentucky statute of limitations. We've got on the graphic 1 year for a personal injury case. That starts off as a generality, that's correct. Is that right?
That's correct. The cases that fall usually in the category for injury on personal injury would be an intentional tort, for instance, an assault and battery. Mm-hmm. But on personal injury, as far as car accident cases go, it's a extension to that 2 year if you are receiving no-fault benefits under your own insurance policy. So you always want to be wary of those statute of limitations, as Don and I were just talking about it. It's we have it in our office, SOL, statute of limitations, but it can also mean something else.
Yeah.
And on that note, let's go to our first call. I believe we have Robbie in Mount Orab. Go ahead, Robbie.
Give us your best shot, Robbie.
Yeah, I was out this weekend, and me and a buddy of mine had a couple drinks, and I dropped him off, and I pulled in my house, and I had shut my car off, and I was almost into my house, and the cops had pulled me over in my driveway, made me get back in my car and start it up, and then they gave me a DUI.
Okay, so listen. Common scenario where you've got what constitutes operation, right, Margo?
That's correct.
If actually in Ohio, if you're sitting in the car and the car is running, you're operating while under the influence if you fit the other criteria. Now,
but they made me get back in, or they was going to take me to jail.
Yeah, well, they took you to jail anyway, didn't they?
No.
They gave you a citation?
Yeah.
Well, you've got. Actually, there's a couple things that need to be dissected there. I can tell you this, with the DUI in Ohio, you're facing stiff fines. I'm not going to ask you about whether it's a first or not. We'll leave that off the air, but I'll tell you that it escalates. You're looking at a minimum 3 days in jail or in some sort of a driver intervention program, which is an inpatient kind of a thing where you've got to stay overnight. You've got at least $150 fine, and you've got up to, well, you can have up to 3 year driving suspension, but minimum 6 months with privileges. It's serious business. That doesn't even count the penalty you pay for the insurance. Insurance just got a lot more expensive for you. This is a big deal. You need help for sure. Them making you get back in, well, there might be a defense there if that's all they've got. But chances are, if that's all they had, they wouldn't have been there in the first place. Margo, do you have anything to add to that?
No, I think that's probably accurate. They probably followed you from some other point, or someone called and told on you. And that can be enough evidence for them to justify an arrest and or citation.
Yeah.
And plus, I think all of us, our tendency, if you're involved with a police officer, is to do what they say when they say it.
Oh, yeah.
That's correct.
Yeah.
And that can sometimes, end up causing a problem. I guess. I mean, I've heard people say, "Do what the police officers say," and then there are other people who say, "You do have some rights, and you should get an attorney before that."
Well, you do, and actually, you have a right to ask for counsel fairly early on, and then you can get advice of the counsel as to whether you should do the test, like the finger to nose and all the other things. Some of the stuff you don't have to do. In fact, most of it you don't have to do. And you need legal advice for it. So, Margo, do you have anything to add?
Unfortunately, a lot of people, I think, have the misconception that they don't have to do certain things a police officer tells them to. Unfortunately, there's a law that basically says that you have to comply with the order of the police officer, but you don't have to perform the test. You can just say, "I throw in the towel, take me to jail," and you're not giving evidence against yourself at the time, because we have the constitutional right against self-incrimination, which is the Fifth Amendment. But all of the things that you do test-wise, the sobriety test, the finger to nose, the walk and turn, can be used as evidence against you, and it's just a really thin line. So there's certain advice that we give people that if they believe you're under the influence, more likely than not you're going to jail. Go to jail, and then you can defend it later.
Okay. Well, we have another caller now. Did you have something else that you wanted to add, Don?
Well, the only thing I was going to say is you don't have to make admissions.
Correct.
And you should never do that. And you should never, ever resist. You don't have the right to resist. You just, if a police officer has pulled you over and he says, "Get in my car," or he says, whatever he says to do, never resist. That's a crime all by itself. You don't have a right to do that. You can contest the arrest later on legally, but you don't have a right to resist the arrest ever, period.
Okay.
That's correct.
Okay, now let us go. I think we've got Debbie in Kenton County. Debbie? Debbie, are you still with us? I don't think we have Debbie. Apparently not. Don, one of the things that you and I talk about often is contingency fees. The idea that many people think that you have to have a lot of money before you go to an attorney. Not true.
Well, you're right. That's not true. And basically, a contingency fee means that you can go to any lawyer, the best lawyers who handle personal injury cases all over the tri-state, Indiana, Kentucky, Ohio. It doesn't make any difference. And you can talk to them for free initially and find out whether or not you got a case. And if you've got a case, you don't have to have money if they're going to pursue it, because they'll do it on a percentage basis. That's what a contingency fee is. It's contingent on a recovery. So for many other types of cases, you have to have money up front. For a personal injury case, you can go to any lawyer you want who handles personal injury cases, and it's free until you actually hire them and go forward.
Okay, great. Now let's go to the phones again. I think we have Buddy in Middletown. Buddy?
Yes.
Go ahead, Buddy.
Okay. My son got a divorce 5 years ago. His wife was given 5 years to get the house and car in her name only. It hasn't happened, and the 5 years is up. What options does he have?
Well, under the divorce decree, there was more likely than not a property settlement agreement that set forth those terms. And those terms are have been ordered by the court for them to perform those. But sometimes you have to go to court on a post-decree matter to ask the court to enforce that provision. And of course, because it's been those 5 years, if the longer he waits to go to court to ask the court to enforce the provisions, the longer he has to pay because of mortgage payments and credit scores and things like that. So he needs to get an attorney to file a motion to enforce the provisions, and potentially even have someone held in contempt for failing to comply with the divorce decree.
I think some people, it's amazing how long these things, that one party can drag this out for years.
That's correct. Unfortunately, our court systems are so clogged with cases that, believe it or not, and I've always said this a lot, Don, about lawyers, our lives go by pretty quickly because we're always looking at future court dates. And before you know it, it's already July, and before you know it, it's October. And it happens to the people who are in our system. It just drags on, just drags on.
One of the things that I've often referred to is years and years ago when I used to do divorce stuff is that the system is only so good as straightening what other people can't straighten out themselves. So when you've got a personal situation between you and your spouse, and it involves kids and property and all kinds of other things, you've got a mess. The court will not straighten it out perfectly. They will just eventually bring it into the matter.
That's correct. And in today's world in divorce, mediation is being used quite often. A lot of us attorneys are certified mediators, and we try to help people come to resolution because they're really common sense issues. For instance, she knows that he's paying and he's not supposed to be paying anymore, so we got to fix the problem. But it can be done through mediation.
Okay. Great. All right, we are going to take a break right now. We will be right back taking your legal questions about anything. Give us a call.